Iku Iluna, please rise. Ia ka aha ho kolo kolo ki eke hana hano ua a ko koa ho maila. This Honorable Supreme Court is now reconvened. Inoho ilahu, please be seated.
All right, please call the case.
Case number SCWC-23-0000388. State of Hawaii Respondent and Petitioner Plaintiff Appellee versus Jonathan P. Spies, Petitioner and Respondent Defendant Appellant. Arguing for Jonathan P. Spies, Andrew Kennedy. Arguing for State of Hawaii, Charles Murray. Argument on the merits.
All right, good morning, aloha everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. And I'd like to welcome our substitute justice, Judge Diane Medeiros. Thank you, Judge Medeiros, for being with us today. Oh, looked the wrong way. Counselor, are you ready to proceed? All right, so we have 30 minutes for each side. Mr. Kennedy, you're going to begin with a 23-minute argument. We're going to give you a warning with 7 minutes to go for your rebuttal. My understanding is you're going to be covering both the issues in the state's petition, responding to those, as well as the issues raised in your petition. So all will be raised in the 23 minutes. Mr. Murray will cover all those issues in his 30 minutes. Then you'll be rejoining us for rebuttal. Very well. Please proceed.
Thank you very much. May it please the court, Councilor Murray. The issues raised in my petition, there's numerous ones. There's about 8 of them. So in this kind of situation where it's not just one issue that was raised, but I think it can be summed up as follows. There was an individual was accused of dealing drugs out of his home. Based on the belief that he was dealing drugs out of his home, a number of search warrants were obtained, 2 search warrants, one for his persons and one for his home. The one for his person was the one that was actually executed and led to the events and the criminal charges. It was executed outside the home while he was at a grocery store in the Waimea Parker Ranch area at the Foodland. The warrant was served on him, his person. Nothing was found. He was not released at that time. His detention was prolonged. While he was still in custody, a statement was made. This statement was in response to conduct by the police officer that it's our position was likely to elicit incriminating response. And from that, he was arrested, his car was seized, and a 3rd search warrant was obtained. That's 3rd search warrant for his vehicle. That was obtained after a canine screen was performed at the station. I think that the arguments, while there's about 8 of them, they can be summed up into a few categories. One would be the defendant's statement after the execution of the search warrant. The other would be the prolonged detention of defendant after the execution of the search warrant. There were the issues regarding the foundation for the admissibility of the drug and the lab results. And then there were a number of issues that were raised related to the issuance of 2 of the 3 search warrants. As the court is aware, the Intermediate Court of Appeals, the ICA, did rule in our favor on the admissibility of the drug results. There were 2 issues, or there were actually 4 points that were raised, which can kind of be summed up into 2 areas. They ruled in our favor on one of the 2, being the training as to the qualifications of the expert, specifically with respect to the devices that were used. But I do have a little bit to add to the other points of that were ours. I'm not sure if the court has a preference of where I'll start. If it's up to me, I'll start kind of in the timeline. We'll start with the statement that was made. This statement, the defendant was in custody. The officers admitted he was in custody. The officers stated they did not have probable cause to arrest him at that time. It wasn't.
Can you actually start, backtrack?
Yeah.
Was that after the search?
Yes.
And how long had he been detained after the search?
Okay, that's a good question. The search happens, I believe the officer's testimony was somewhere around 3 minutes, if I have my recollection of the record correct. It was about 3 minutes. So there's a body-worn cam that shows what happened. He is pulled over. They detain him as he's pulling into a parking spot. One officer pulls in, a uniformed officer. After that, the vice officers show up, and the lead detective is Officer Gaspar. He shows up. They execute the search. He has nothing on him. At that point, the detention is prolonged. It's not 10 minutes. It's probably not even 5 minutes. The officer's best recollection was about 3 minutes.
Well, you know, so the officer, I think it was a detective, the vice detective?
Vice officer.
Okay, so he's saying, hey, after this search, the unsuccessful search of the person, there's a reasonable suspicion based on his training experience that drugs might be nearby, somebody who purportedly possessed drugs, and then there's a second individual in the car. Are these circumstances sufficient to justify a 3-minute extension of Spies' seizure here?
Not at all, Your Honor. The circumstances were that the inception, the basis for the stop, the inception of the stop was to execute the search warrant, right? And the search warrant was based on two elements, I guess. Is one, dealing drugs out of the home, and training and experience that people who deal drugs might have drugs when they're out and about. So I guess to answer Your Honor's question, we have to look at it if an individual is accused of dealing drugs out of their home on one day, a number of days, weeks even later, can the officers go and confront that person at the Foodland parking lot based on the training experience they dealt drugs out of the home on earlier this month, so now we can go stop them wherever we want to stop them? I don't believe that would, and it's a difference between we're going to stop him and arrest him for what he did on that day prior, but we're going to stop him, we're going to seize him, and we're going to initiate a search and an investigation. So I don't believe that that would give rise to the probable cause.
And the reason why I brought that up, it's almost suggested by the state that, you know, that the unsuccessful search somehow turns into an investigatory stop at that point.
It does, because the inception, and this is the Escobedo and Alvarez type cases, is, you know, what is the inception? What was the purpose of the stop? And the purpose of the stop is to execute a search warrant. And it wasn't to investigate his car. It wasn't an investigatory stop. It was, we are going to execute the search warrant. That is what they had the authority to do. So unless they can point to specific articulable facts that show why this should have gone beyond what the search warrant just allowed them to perform, then no, there is no.
So is it your position then, and everything after that, the search was pouched, such as the consent is out?
Absolutely.
And that everything after that is excluded per the exclusionary rule?
Yes.
Did you cite to State versus Iona?
Off the top of my head, I don't know if I cited to that. I know I focused on Alvarez and Escobedo.
Iona is the case where someone was pulled over for riding a bicycle without decals. It's opinion from a couple years ago, and he was. We held that because although he was pulled over, you know, the initial stop was fine. When the purpose of that was finished, in terms of riding the decal, the fact that they continued to seize him made him stay, and then did a warrant check, which revealed a warrant, which then they did a pat down and found contraband. That arrest was illegal. So we have said that, you know, you can't seize anyone for longer than necessary for the purpose for which you've stopped him. And this appears to be that type of situation.
Absolutely, I would agree. And I think that Escobedo and Alvarez are along the same type of lines that we had a lot of these cases in Big Island in years past, where they get pulled over for one aspect and then it spins off into a larger investigation, and similar to Iona, and I think it's along the same lines.
So if he had asked for consent to search immediately, would that be a problem?
Prior to the execution of the search warrant?
No, after the search warrant. If the next thing he did 20 seconds later, would that have been a problem?
Yes, I do believe it would be a problem, but for a different reason.
Okay.
And that reason would be because he's in custody. And at that point, and I know there's the state versus Rippey is a different case if we want to start diving into that area.
Yeah, we'll talk about that. I just want to understand the timing. Is it the fact that it was 3 minutes, or would any amount of time, once the search is complete, he goes out, they cannot ask him if he consents to a search of his car?
I mean, I'm of the belief that you finished your purpose with this individual, he should be released to go. and it shouldn't be prolonged.
So 0, you cannot.
I don't think that they. That
What,
they
what
should-
about if he Mirandized the person? Say, hey, look, you are free to go. I am going to tell you your Miranda rights. That would be okay, wouldn't it?
Right. Well, I don't want to spill into issues too much. In this case, I know you give me a hypothetical. In this case, he specifically was not free to go, and the officer testified he was not free to go. And what you're saying, if he said, hey, you're free to go, and you don't have to answer me, and you have the right to remain silent. If you want a lawyer, you can have one. And then he asked him that. That's what they should do.
In consent, there's a case called Robinette versus Ohio. It's a 1996 U.S. Supreme Court case. Maybe you're familiar with it, maybe not. But essentially, in that case, it's a traffic stop in Ohio. The means and the reasons for pulling the person over were done. It's all done. And then the police officer says, hey, can I consent? Do you consent to search your car? The person always consented a car, and a bunch of drugs were found. That case shoots up the federal pipeline. The feds, SCOTUS in 1996 said, that's okay. You don't need to tell the person they are free to leave, like Ohio ruled in their state court. Justice Stevens, in his dissent, said, hey, federalism principles allow states to impose rules such as after a seizure is done, whether it's a traffic stop or not, before consent, and advice that the individual is free to leave. Do you think that's a rule that perhaps we should think about adopting here to preserve both police investigations and the rights of somebody who's stopped?
Absolutely, Your Honor. I practiced in a different jurisdiction before coming over here, and when I came over here, I was shocked to learn that they don't Mirandize people right out of the gate. In New York, you come in, you get someone, you put them in the car.
Well, this is a little different. This is once it's all. I'm not talking about Miranda. I'm just saying, before a consent to search, there's no reason for you to be here. You can leave. So there's 2 prongs. One, you're asking for consent to search, but you're also saying you don't even have to be here.
And so along that lines, absolutely. And I think going with that, because the consent should be knowing and voluntary waiver of their rights, and they should be informed of their rights, and included within that should be informed of their right not to be there if they don't want to be there.
Does it matter that the other individual was in the car and that she made a statement at some point that there's things in there that might be bad for her?
So the other individual was taken out of the car and was off to the side.
Mm-hmm.
And she wasn't involved in the interaction between Officer Gaspar and the defendant in this matter. I believe that her statements were somewhat prolonged. It's kind of muddled as to when those statements were said as to when Officer Gaspar finished the execution of his search warrant.
But if she indicates there might be contraband in the car, isn't that a factor that could support the brief detention of Mr. Spies while the officer decides how to proceed?
That could be a specific articulable fact that they could point to.
Yeah. Why don't you talk about the request or consent to search? So is that the request that was made, was it reasonably likely to result in a incriminating statement?
I believe so. Now the Rippey case, is what the ICA relied on. I understand that's your case, Your Honor, and I don't want to read into it that stuff that you did not intend. But I don't believe that the Rippey case creates a categorical exception to the Miranda rule. I don't believe we do categorical exceptions where any request to search, therefore, is not interrogation. The test is simple. Is he in custody, or is the defendant in custody, suspect in custody, and is the conduct of the officer one that's reasonably foreseeable, likely to elicit an incriminating response? Now, in Rippey, the situation there, the court held it was not. It was a yes or no question, simple as that. But in this case, it was a little different. He asks, the individual kind of mutters something like it's in there. So it goes beyond just yes or no. At that point, he goes, I wasn't sure what he said. I wanted clarification. So I asked, what did you say? So he goes beyond just a yes or no. And in Rippey, a big point was, it wasn't the answer to the question that was likely to elicit a incriminating response, but rather the contents of what they could find that was going to be incriminating. In this case, it was the answer to the question that was incriminating and snowballed the whole thing.
So why not allow that initial answer and then suppress everything after it, beginning with what? when the officer said what?
Well, I believe that the initial question, again, that Rippey, I respectfully disagree with some of Rippey, but I guess you could draw a line and say that there were two areas of question and that he wasn't clear on the first one. And then therefore it was the clarity that, because really it was the second one that was the more incriminating one. Everything you're looking for is in the console as opposed to it's in there. But I believe that, he's there to execute a search warrant, thinking that there are drugs somewhere, and he's asking this person to search. I believe he's asking a question that he is reasonably likely to elicit an incriminating response.
There hadn't been, unlike some cases where the request to search takes part as a feature of a prolonged, interrogation that had already begun. Not really questioning had gone on in this case. So before the officer said, "Can we search your vehicle?"
You are correct that it wasn't this 10-minute questionnaire of 5, but it wasn't just out of the blue. It wasn't coming up this consensual encounter and, hey, can we check this out? I mean, there was sufficient deprivation of his liberties. He was detained for the execution of a search warrant. So it wasn't just this matter of nothing happened and then we asked to consent. There was sufficient interaction beforehand.
Well, in Rippey, it distinguishes Blackshire, which is where there was interrogation before the request to consent. So, I mean, in some ways, your argument is this is more like Blackshire.
Exactly.
Yeah.
It wasn't out of the blue. There was an interaction. It might not fit neatly within Blackshire's interrogation, but there was deprivation of his liberty. There was back and forth.
So clearly he was in custody, but was he arrested at that point? He was just seized for the execution of the search warrant of the person?
There's no bright line test as to when arrest occurs versus seizure. He was detained. The officer was asked, after the execution of the search warrant, was he free to leave? The officer said no. The officer made clear he was never free to leave from the point they pulled him over to execute the search warrant until the time he went into custody.
And he was never Mirandized?
He was Mirandized at the station.
At the station, but not on the scene?
Correct.
Despite all of this banter?
Correct.
Why do we not have a bright line rule that says that, hey, when you seize someone or you're arresting someone, you're seizing someone to execute a search warrant on the person, you Mirandize them?
We should. I don't. That's a great question. I don't understand. They do it in other spots. There's nothing that says they cannot do that. Along that same line, I mean, I understand where the officers.
We have so many of these cases where the issue was the statement voluntarily made. And was it a spontaneous utterance? Because we don't have a bright line rule that says, hey, you Mirandize.
That was the word I was going to say, spontaneous utterance. We see that in police reports all the time. There's a section called spontaneous utterances in police reports where they put in the before we Mirandize them, and then we end up doing these hearings back and forth, and now we have body cams. It's simple enough for them to do. I understand where they want to have the AOR recorded and preserved so they can say, hey, look, he clearly understood it and he signed these boxes. But that doesn't preclude them from doing it at the initiation of the seizure. And they do that in other jurisdictions. And that's, I'm a little thrown back to why they don't do it here. But it's their choice not to do it. I mean, there's nowhere it says you can't do it. I mean, they're the ones electing not to do it. And at the end of the day, it's their burden to show that these statements are voluntary and that they're not in custody.
Well, they want to get a statement, so they're not going to do it. Right? I mean, that's the reason.
That's the choice they're making, though, and people's rights are.
And is that fair? Probably your answer is no, right?
No, people's rights are at stake here, Your Honor.
Did you want to talk about the state's petition and the ICA's ruling on the admissibility or the foundation for the drug test?
I'm just going to grab my water.
Sure. Absolutely.
So, the ICA, we believe, correctly ruled that the foundation wasn't met. The state has tried to distinguish this by talking about, the Texera case. And if I may, first, the ICA ruled on one of I raised about 4 issues where the foundation was deficient. One was the manufacturer's requirements, another being the lack of training, and those sort of blend together. The other was the proper order and maintenance of the devices, as well as the lack of the lab accreditation. The ICA did not rule on my third and fourth points, the second group, the maintenance of it, because they said it wasn't properly preserved. I strongly disagree with that. During the trial, I had made a point. I filed the motion to eliminate. We don't always do that in this case, but I knew this was the issue in this case. I filed the motion to eliminate. And in that motion to eliminate, on page 8, was a section about the measuring instruments must be in proper order. I believe I called it quality and maintenance of the instruments, which would go to show, the calibration that they're reliably working. So during trial, we had discussed with the judge, because we're trying to avoid speaking objections and doing it in front of the jury, and everyone kind of knew what the issues in the case were. I said, I will refer on the foundational stuff, just refer to the motion to eliminate, and the judge said that's fine. And that's how we decided to do that. So it was page 8, and it was quality assurance and maintenance, and it cites to Subia, it cites to Wallace, and it cites the foundation requires that devices in proper order. So I think that was preserved, the issue of the devices not being properly ordered. So the state, the ICA, I believe, was correct in showing that they weren't properly trained, therefore they weren't properly qualified, and they shouldn't have been able to testify. There are 3 prongs that Long it's not just Long, it's Maneva, Long, Texera, all of them talk about. And first is the qualifications of the expert. The second is the application of the expert's application of the techniques. And then the third is that the device is in proper working order. So the ICA, in their rejection of the state's motion for reconsideration, discussed how the state was focused more on the third prong as opposed to just the first prong, which goes to the qualifications of the expert. And the qualifications of the expert in this case were such that they weren't trained on the devices. They didn't know much about the devices. An interesting part of Texera is they specifically distinguish Wallace and Maneva, and this is on page 531 of the Texera case. They say, first, this is not a case where the expert witness lacked personal knowledge as to whether the device was properly calibrated at the time it was used, as was the situation with the electronic balances discussed in Wallace and Maneva. So in Texera, there was a lot of foundation as to what they knew about it. I mean, they pretty much in Texera said that this one went so far above and beyond what foundation is required that we're not going to worry about the calibration. The instant case before us is more like Wallace and Maneva. In Wallace and Maneva, they didn't know about the calibration. This individual had no idea about the calibration. They didn't know. They said the company comes in and does it. So
I thought there were records admitted into evidence.
They were post-dated. The test was done in February I believe February 2021. The records showed the calibration was done in July and November of that year. So even if we fall back on this idea that, well, this was a well-trained, and it showed that the lab was working and the reliability, no. The evidence was far deficient. They didn't even have the lab accreditation was from the summer as well. So all the records were post-dated.
Was that argued, the
Yeah.
post-dating?
Yeah, it was. I mean, that was my closing argument. That was
In your closing argument?
And I mean, when I made the argument with the court, I mean, I relied on it. I don't know exactly what I said, but I was relying on motion eliminate number 1, which talks about the quality and maintenance of the devices. So I'm not sure, we're in the heat of trial. We do what we can to preserve the issues as best possible. But there were a lot of questions asked about it. This wasn't something that was just found later on, like, oh, how did we miss this during trial? This was questions directly asked of her. What is the date of the calibration? Oh, that's after the test was performed. It was pretty clear at that point.
Weren't there other exhibits introduced that showed that there was maintenance and calibrations done, however, before and during
No,
the time?
the exhibits that were introduced were from after. They were from July and November. So there's 3 devices. So there might have been one for one of the devices that was properly done, but the other 2, I have it in front of me. It's one was from July. So the Mettler-Toledo scale, actually, I'm sorry. The Mettler-Toledo scale was calibrated in April of 2021. The FITR machine was not calibrated until November 2021, and the lab accreditation was July of 2021. The tests were performed in February of 2021.
I thought Exhibit 40 was an assurance checklist from January 2021 through March 2021.
That was probably for one of the other, because there were 3 devices. I believe that's my 23 minutes.
Yeah, if you want to
I was gonna
stop
say
there, you
7.
can. I guess.
You have to have a
I
question.
guess the one question I would have for you is, do you agree with Mr. Murray that it matters that we're dealing with an expert witness here as opposed to a police officer who's operating a piece of equipment that he or she doesn't really understand how it works?
No, I don't. No, not necessarily. I mean, we're dealing with equipment, and I think that, part of the long test is that they have to be qualified, and I think part of the qualifications is that they know how to use what it is that they're using.
So in this case, I think it's Scheffelbein. Ms. Scheffelbein
Right.
testified, I believe. She was trained by her supervisor, Kathy Pung. Is that right? So her testimony, and admittedly, this is way at the end of her testimony. She says, Kathy Pung was trained from the people from Thermo Scientific, and we have the manuals from Thermo Scientific themselves that are then used to write our procedures, which are accredited.
I don't believe she had firsthand knowledge as to Kathy Pung's training.
You didn't object.
All right.
I don't see a hearsay objection there.
All right.
And she's an expert too, right?
Yeah, no, I think that she still has to show she's qualified on the devices, and there still has to be a sufficient showing as to the qualification.
Right, but the argument is we don't know that it was sufficient because we don't know that it's what the manufacturer mandated. She talked a lot about her training, months and months, depending on the piece of equipment. One was for a day, that was the scale. The other, I think the UV was a week, and then the infrared was, weeks and weeks. So the argument was we don't know whether that was good training or not, but doesn't the testimony I just read provide an answer to that question? It's training consistent with the manuals and the training provided to her supervisor by the company?
No, she showed up, and someone at her office showed her how to do it. I believe that there needs to be a higher level of showing that her training is in accordance with what the manufacturer actually requires.
Very well. Thank you.
Thank you very much for your time, Your Honor.
Good morning. May it please the court, Mr. Kennedy. The issue about foundation for lab testing by an expert is based on what is found in Long, which are the qualifications of the expert, whether the expert employed valid techniques to obtain test results, and whether the measuring device or instrument was in proper working order. Here, there's plenty of testimony at trial that the measuring device was in proper working order, whether we're talking about the FTIR or the balance scale.
What about the post-dating? What about the testing having been, or was admitted being done after the actual testing?
The ICA found that the defense waived that argument because it wasn't part of the motion to eliminate number one. Regardless, the facts are, the testimony at trial was that these people, Kathy Pung, Scheiffelbaum, I believe there was a third individual that actually came and testified about records and whatnot. The records showed that from January to these post-dated dates, they maintained daily logs of both the FTIR machine as well as the scale and balance. Those weight checks, they did weight checks every day. The testimony was before they ever used the instrument, they used the weight checks to test the scale to make sure it was reading accurately. That's what each analyst did as part of their normal daily routine. And that is what is required to show and establish that these instruments are in proper working order per Long and Texera and Wallace and the whole litany of cases. Now, regarding the question of hearsay and that was just brought up, this is an expert. It is different than an officer with a radar gun on the side of the road. That's lay testimony. That's not expert testimony. There was no objection, or the objection wasn't about the expert's qualifications. It wasn't about Ms. Scheiffelbein's capabilities as an expert drug analyst doing this drug analysis in a lab that's certified. The other thing that's different, and this is more of a common sense thing, from a radar gun by an officer on the side of the road, that is not verifiable. There's no way to check that. Here, drugs, DNA, like in Texera, there's nothing stopping a defendant from having his own expert test those drugs and weigh those drugs, just like they can on DNA. So instead of playing a game where we test to see if the right questions have been asked on foundation. Let's really get to this search for truth. Let's have a standard that requires defendants to engage in the search for truth that we're supposed to be engaged in.
Is there a burden? Is there a burden for the defendant to come forward with any evidence?
There's no burden, but it goes to the weight and credibility. And I think that's where this issue needs to be focused on, not the foundation for the admission of expert testimony that can be checked, but let it become a weight and credibility argument. The defendant doesn't have any burden, you're right, the state does. As long as the state lays the foundation to get an expert to come in, that they've done a test, that they have the training experience and know how to do these tests, they can give their answer, the defendant can cross-examine them, question their credibility, the weight of their testimony as an expert, and they can bring their own expert in if they want to go that extra step. But that's where the focus should be on. So if we really truly are about a search for truth, that's what the courts are supposed to be. That's what these trials are supposed to be about. Now, regarding the other issues, first off, for Miranda to apply, it requires custodial interrogation. I understand Justice McKenna's position about the value of a bright line rule, but that's not what Miranda requires. Going back to the core case, Arizona, Miranda, there must be custodial interrogation for Miranda to be necessary. If you create a bright line rule that says we're going to Mirandize them before we get to custodial interrogation, then you've departed from Miranda. You've departed from the U.S. Constitution.
There's no issue with respect to custody here, right?
Not in this case, no.
Right. So you're saying there was no interrogation?
No. No interrogation. That's the state's position. Because the question of can I search the car cannot reasonably expect to listen to incriminating statement.
What about all the banter before that and the conversation before that?
The banter before was initiated also by the defendant. According to the testimony at the motion to determine voluntariness hearing, the defendant was asking about the warrant. He was presented with the warrant, which is required under the law, and he asked questions of Officer Gaspar about the warrant. Officer Gaspar couldn't remember exactly what he said, but he said that it was all about the warrant. He was answering the defendant's questions. That also is not interrogation. He's not asking the defendant or engaged in conduct that could reasonably be likely to elicit a criminal.
What about the at least a 3-minute detention after the search had actually been done?
The 3-minute detention, he said that was what the testimony was at the MTV. The ICA pointed out that the findings of fact, which were uncontested by the circuit court, make no mention of the time. So the first issue, before we even get to there, is this argument waived? Because the findings of fact weren't challenged, and the findings of fact on the order do not mention anything about the time frame from when he was searched to when the question is asked for consent to search.
I mean, are you suggesting then that if we read transcripts like we do in every darn case, that just because the judge doesn't make a finding, that we are to ignore what the detective testified to?
I'm just making the argument that argument was waived because the findings weren't challenged.
Well, everything was waived in this case, according to you, it seems. Let me ask you this. I'm going back to your interrogation idea. And Mr. Kennedy's, not idea, your point, your argument. Mr. Kennedy basically says there's two kind of questions. And as I read the affidavit in support of the search warrant prepared by Detective Gaspar, he actually asked twice for consent, and that Spies refused twice. Then he asked the thing about the it. I mean, then Spies says it's in the console area. But that didn't stop then. And I think what Mr. Kennedy was saying, or what I at least heard, was that second question then was reasonably likely to elicit an incriminating response. What's your position on the second question?
Are we talking about the question of what he said initially, or are we talking about after?
Okay, it's yeah, and it seemed like there was two questions. There was the follow-up question by Gaspar. That's what I'm talking about.
If it's I'll just explain it so it's absolutely clear. If the question is, can I have consent to search the car? Spies says it's in there. Gaspar says what? I don't think that's interrogation, because at that point the testimony seemed to be that Gaspar didn't hear him and wanted to make sure he heard him correctly. Now, an additional question after he repeats it, if it's what's in there, under the circumstances, he didn't know what he was talking about. Gaspar testified he didn't know what he was talking about.
I didn't get the impression Gaspar didn't hear. I think he was asking for clarification, asking what it is.
I think there were two, my interpretation was there were two whats. Like, what did he say initially, followed by what it is, or where it is in the car. I may have that wrong. But either way, I don't think it's interrogation because Gaspar didn't know what he was talking about. Just saying it's in there, and then he follows up with what you're looking for, the warrant, it's in there.
But didn't Gaspar later on in his affidavit say that he knows that it was commonly referred to as narcotics?
And this was a narcotics investigation, yes. I mean, I can certainly see the argument that everything that follows the what after it's in there, anything after it's in there, I can see the argument that perhaps that could elicit an incriminating response. I don't think that's what was happening here, but I can see that point. And regarding going back to the prolonged detention question, Estabilio does say that, when there's been a prolongment, the question is, was it reasonably related in scope to the circumstances justifying the initial stop? Here, I would argue that yes, the initial stop was to execute a search warrant on a person for drugs, narcotics, so there's probable cause to believe that Mr. Spies would have narcotics on him on this given date. When the pat-down search, the search is done of his pockets and his person while he's standing next to a car, produces nothing. The request to search for consent, the request for consent to search the vehicle that's right next to the defendant is still reasonably related to the initial stop, i.e. that narcotics investigation. This isn't a case where they pulled over Mr. Spies for a taillight being out and then decided to turn it into a narcotics investigation. This was a narcotics investigation from the get-go.
Well, it's not the case where he was pulled over for a pretext on a light that's out, because they didn't have to pull him over at the Parker Ranch shopping center near the Foodland with all sorts of pedestrians and people in the public. I mean, they could have waited till he got to his right. They could have done anything. They could have tailed him. So I guess, what's your response really to almost this bootstrapping? Is like, we didn't get a search warrant for the car. Here we got him. He's free to leave, but we're going to keep him there to go into the car with the consent. That seems pretextual.
He's free to leave to go back to the house that they also have a search warrant for that they never executed. So there maybe is even an inevitable discovery argument. At least, eventually they could have went back to his house. They could have waited and went back to his house and searched his house too. They didn't.
Or they could have followed his car because maybe he wasn't going back to the house. Maybe he's going to a drug transaction, and then boom.
Yes, but instead they pulled him over and searched him personally and asked for consent to search in a very public, very busy public shopping center midday with cars coming in and out. So this is not your typical situation either where we're concerned about prolonged custody and detention, because this was a very public place with people coming and going all the time. The idea that his rights would be violated in such a public way kind of undermines the argument that the whole basis for what we're looking for when we're trying to avoid these kind of unlawful detentions.
But isn't the right to not be unlawfully detained and the exclusionary rule excludes evidence based on unlawful activity? This is a unlawful seizure. So why wouldn't then the evidence procured based on that unlawful seizure be excluded?
Certainly the right to be secure in your person goes beyond just, being secretly whisked away by the police to a place where no one's at. You're correct. But this was a brief detention. No matter how you parse it, did it go on past the search of his person? Yes, but it was still brief. Whether it was 3 minutes, 2 minutes, or 1 minute, that's a brief interaction with police.
Why wasn't he just told, okay, we didn't find anything, you're free to go?
Because he had probable cause to believe that Mr. Spies had drugs on him, was engaged in narcotics transactions. That's why he got the 2 warrants to start with. We don't know why he didn't get a warrant for the car. Maybe he didn't know what car he'd be driving. But when he sees him next to a car on the day he executes the search warrant on his person, there are items in that car. It's reasonable to believe, as he put in his warrant for Mr. Spies, that drug dealers carry bags with them. They have bags. He's outside the car with no bag. So where are the drugs? The drugs probably aren't in your front pocket if you're talking about dealer level quantities. So it was a reasonable belief to think they're probably in the car. I want to continue my narcotics investigation, which I already have PC for, so I'm going to ask for consent to search. He didn't just go into the car. He followed the rules. He followed the law. And then he went a step beyond because he got a canine search after he seized it, which I don't even think he needed at this point because of the statements Spies had already made, as well as the passenger.
Are you familiar with the Robinet case that I mentioned to
I'm not, Your
Mr.
Honor.
Kennedy?
With respect to that, I'm sorry, it was the idea that the states can basically have
Well,
higher.
and what Ohio did was, once the seizure is done, whether it's a investigatory stop or otherwise, such as this situation, before the consent, you're free to leave. That's basically what they said, just to clarify.
And again, I think that kind of goes to the idea of the bright line rule too. If those are the kind of direction we want to go, that's something the legislature should pass because that's their.
The legislature should
responsibility.
construe the Constitution?
I'm sorry?
The legislature should construe the Constitution, not this court.
The legislature should pass a law mandating these kind of bright line rules that aren't grounded in constitutional jurisprudence. I think that's what the court wants, or believes is appropriate.
The right against unreasonable searches, seizures, the right against self-incrimination are part of the Hawaii Constitution.
Correct. But the traditional interpretation has been that these are not, these kind of rules about advising them they're free to leave or advising them the Miranda rights before there's interrogation haven't been found to have been required by the Constitution. If we want to require those things, then it should be done through a legislative act. If there's not any other questions, I don't have anything else to
Can you
add.
come back to the testing? So what was the basis? Where did the ICA get it wrong in terms of finding there was an adequate foundation for Ms. Scheffelbein's competence with regard to the infrared tests? Because that's the determinative test, right?
Yes, the FTIR, the weight also goes to it because this is a Prodang 1.
The UV is not critical.
No, it's a presumptive test,
All
not
right,
a confirmatory test.
Where did the ICA get it wrong as to the infrared test?
On this one, they got it wrong because they treated Ms. Scheffelbein as if she was a police officer handling a radar gun instead of an expert trained and with an education and background in analyzing drug substances. Here, she testified that she knew how to work the machine. She was trained how to work the machine in accordance with the training received by her supervisor, which is based on the manuals provided by the manufacturer. But more importantly than that, she knew the machine was working properly because they did the daily checks, and there's testimony of that. These machines were working properly, functioning as they should, which is what the courts have said is required. When you look at Long, you look at Wallace, when you look at Texera, that's what is required when you're talking about an expert testifying as to scientific test results. There's no question these machines were working properly. That's all in there. It's all in the testimony. She doesn't have to be trained according to the manufacturer's recommendations or requirements. First off, there's nothing in the facts or the record of the case that there are even manufacturer's recommendations or requirements. So I don't think we can judge her training on something that's not even there, that we don't even know if it exists. But what we do know is that she's trained, she's certified, the lab's certified. She used this machine and she made sure it was working properly the day she tested these drugs, both the FTIR and the weight of the scale.
How do we know the lab is certified?
There was records admitted into evidence.
But the records were from the summer.
Yes, they were post-dated.
So what's the argument as to why they were certified in April or February?
It may not have been, well, a lab certification procedure, I believe there was testimony that, that's a process. It's not something that is instantaneous. They come in, they check the lab. Either way, that they were given a certification saying that this lab meets the requirements of the national certifying body. It's good going forward, but I would also argue it's good going back because you can't get that certification if you're not meeting the standards leading up to when you actually get the physical certification. And the same would apply for the certifications of the actual instruments themselves.
Very well. Anything further for the court at this time?
Thank you.
All right. Mr. Kennedy.
I may briefly, I don't have much to add, but I want to go back to the idea of when he was seized and the reason for the seizure in this case, it was to execute a search warrant. It wasn't to conduct a prolonged drug investigation. There was a comment made in that argument that, Officer Gaspar had PC to believe a drug investigation. I asked Officer Gaspar during the hearing, did you have probable cause to arrest him when you approached him? He said no. He said, I didn't have it until the statements were made. So we go back to the question Justice Edens asked earlier about the reasonable suspicion. And I don't think that someone dealing drugs out of their house on one day gives rise to go search that person in Foodland sometime later. Like that doesn't work. And the warrant is a separate issue. They were there to execute a search warrant. That was the basis for the initiation of the seizure. When that was ended, the liberty or the ability for the police to restrain this person's liberty should have ended as well. Also, I don't believe that this is a legislative issue.
What if the officer saw a bag of looked like a crystalline substance partly sticking out from under the seat? Still free to go, or could the officer detain him for some short period of time to determine how to proceed?
At that point, they would have specific articulable facts to continue an investigation.
And the fact that the officer is aware that folks who deal in narcotics often keep stuff in their truck or their vehicle as opposed to on their person, is that not enough?
No, I don't think training experience and that type of generality is enough. I think that there has to be a specific objective fact that they point to within the specific case to show why this individual might meet with that training experience. Otherwise, whoever was to deal with drugs out of their house would be fair game to be at the beach or, weeks later, like, oh, we had information he did at the house, and based on our training experience, that means he probably has it otherwise, so we can just go hit him up wherever. I don't think I think they have to be able to point to why at this point in time, on this date, this person we're going to search right now is likely to have the drugs.
What is the state of the evidence in terms of what occurred in those supposed 3 minutes?
I'm sorry, I heard
What is the state of the evidence in terms of what supposedly occurred in those 3 minutes after the search of the person was completed? There's no findings by the trial court as to that, but in terms of the specific testimony of either Officer Gaspar or others.
He's not entirely clear. Unfortunately, he was not wearing a body camera. So we're relying on the other officer's body camera. So we just have his report to go by. He recalls that he patted him down. About 3 minutes went by. I know the body camera does show that it's not like Officer Gaspar left and came back. Right. They're standing around the car. And,
he's going and talking with Valderrama. He's doing stuff like that.
Exactly.
The other person, the other passenger.
There was another officer who, actually, Gaspar does walk over. He leans over. He talks to Sierra Valderrama for a few moments, and then he walks back. And I apologize, I don't have it all to recite.
That's not a reasonable investigative step to take under the circumstances?
No, I believe that they seized this individual for the purpose of executing a search warrant. They executed the search warrant. Nothing was found. At that point, he should be free to leave.
Unless there are other circumstances.
Yeah, if they see some crystalline substance sitting there on the floor, as you mentioned, then okay.
And the doors were open to this car, right?
But they didn't see anything. The doors were open, but he didn't see anything. He didn't point to anything like I saw something in the car. It was the statement. He said it was the statement when he said it's all in there. That's what led to the taking him in and furthering the investigation.
Very well. Anything further for the court?
No, I have nothing further. Thank you all very much for your time.
Very well. Okay. Thank you to both of our attorneys today for your arguments. The court will take this matter under advisement.
Iku Iluna, please rise. ua ho'oku'u ia mai nei ke aha ho'okolokolo ki ike hanahano o ka maku'aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.